So yeah, I'm Lance Baynham, and I'm the Discrimination Case Worker at South West London Law Centres. Been in the role for, since January 2021, and I volunteered in the employment team at the Law Centre before that. So I personally work on under a legal aid contract with people with discrimination claims, including disability discrimination claims. And then the Law Centre employment team also provides advice appointments, short appointments to provide people with advice on a whole range of employment situations. But yeah, that's my role, and I'm very pleased to be here to talk a bit about MS and employment. This situation involves a number of kind of personal or emotional considerations, which I obviously can't talk to so much, but I can talk a bit about the legal considerations that apply. And so obviously it's going to depend on your personal circumstances. Some employers might be great, really open and receptive, and others, I've seen in my role, not all employers are brilliant. One thing to say is that a number of the protections that the Equality Act provides for people with disabilities only apply if your employer knows or could reasonably know that you are disabled. So, for example, we'll talk, I'm sure, in a bit more detail about reasonable adjustments and the duty an employer has to make reasonable adjustments in more detail later on. But an employer only has that duty to make reasonable adjustments if they know or could reasonably be expected to know that someone has a disability. And so if you want your employer to make some kind of adjustment, then obviously that's going to involve some sort of conversation. Yeah. So if you're in that situation, your condition's progressed and you do think there needs to be some adjustments made, then that's probably a conversation that you're then going to inevitably have to have. Yeah. Let's say you're in a position where you've just been diagnosed, your MS hasn't progressed to a level yet where you require some sort of adjustment to the role you're doing, then it might still be a good idea, and obviously again this depends on your circumstances, but it might still be helpful to have to disclose that to your employer so that they're aware, and so that if further down the line you then have to have another conversation, if your condition's progressed and you're then having to talk about adjustments, that hasn't come as a kind of surprise to your employer. It's already been an open, kind of honest and conversation between the two of you. And I think there's been some research as well which shows that people that disclose their MS or other conditions generally sort of stay in employment longer and so on than others. And obviously that's very broad sort of research rather than your individual circumstances. But so that's what I say about the benefits of an employer or of disclosing. But a couple of kind of qualifying points on that. For your employer to know that you have MS, it doesn't mean that everyone in the organisation that you work for needs to know. So, like I said, some protections only apply if your employer knows that you have a disability. But it might be that if you just spoke to, say, someone in HR, then that would count as your employer knowing, and you could say, I don't want all of my colleagues to know, and I'm worried about if they might treat me differently. That would mean that your employer still knows, but again, not everyone that you work with knows. And your employer also has duties of confidentiality towards you, so they wouldn't be able to then just go spread that knowledge around. So yeah, I think generally it can be a good idea, but obviously it depends on someone's individual circumstances to some extent. The Equality Act, which is the most relevant piece of legislation, is the source of protections that apply to disabled people. And actually what that says is that there are a number of conditions which are automatically deemed to be disabilities. And MS is one of them. It means you automatically are considered disabled and have the benefits of the protections that the Equality Act provides. And again, you might still not like to think of yourself as disabled, and that's absolutely fine, but you do have the protections of the Equality Act. So the Equality Act prohibits certain conduct in accordance with what are called protected characteristics. And those are things like race, sex, age, sexual orientation, and so on, and also including disability. So there are a number of protections that apply. So you have protection from direct discrimination, which is where an employer treats someone less favourably than someone else because of a protected characteristic. And likewise, protection from harassment, so unwanted conduct related to a protected characteristic. I'm not going to talk about those in much detail because they apply kind of across the range of protected characteristics. But there are a couple of protections that apply specifically for disabled people. The first is the duty on an employer to make reasonable adjustments, which I'm sure lots of people will be familiar with in terms of just hearing the concept at least. So that duty is essentially a duty on the part of an employer to adjust any what are called provisions, criteria, or practices, commonly referred to as a PCP, to avoid the disadvantages that disabled people face. So essentially, it's a positive duty that an employer has to adjust its policies, practices, requirements, and so on, if they create some kind of difficulty for a disabled person compared to someone who's not disabled. So let's say an employer's practice is that people work pretty continuously from when they arrive at work to when they finish work. And let's say one of the consequences of someone's MS is fatigue. And that makes it difficult to work continuously for that period of time. An adjustment to that practice would be that you have rest breaks on account of the difficulty that that requirement has for you, given your disability. So that's kind of an example of how that would work. One other specific protection that disabled people have is what's called discrimination arising from disability. And what that is it prohibits an employer treating someone unfavorably because of one of the consequences of their disability. So let's say one of the consequences of your MS is that you have to have quite a lot of time off work for health-related reasons, for treatment, for recovery, and so on. And let's say eventually, an employer then says that your level of absence is unacceptable, and they dismiss you as a result. Now, the reason for that treatment would not be your disability. In other words, if someone without any disability had the same level of absence, they would be treated in the same way. But the reason for the treatment, which is the level of absence, is a consequence of your disability. And so if you were then treated unfavorably because of that, that's what this provision of the Equality Act prohibits. The caveat to that, and it's an important one, is that that unfavorable treatment can be justified. So there is a point at which, if you've had enough absence, or absent for long enough or frequently enough, that an employer could be justified potentially in eventually dismissing someone as a result. But they're going to have to show that they didn't really have any other option. There wasn't any less drastic treatment they could have done. Have they taken steps to help the disabled employee with their absence? So that they'll have to make sure they can demonstrate all of those things. Because of the risk otherwise that people with disabilities will be treated unfavorably because of the consequences of their disability that they can't do anything about. So there's no kind of shopping list of potential adjustments. There's no set limits at all. It's so it could potentially be anything. So if there is a policy or a requirement or some kind of practice that your employer has that puts you at a disadvantage because of your MS, compared to people who don't have MS, then the duty to make reasonable adjustments potentially arises. So anything that might avoid that disadvantage is potentially an adjustment. And then the question is just, is it reasonable or not? And that will depend on things like, would it work? Would it actually be effective? How practicable is it? What would be the consequences on other employees? All those kind of things. So having said that, that there's no set sort of potential list of adjustments. There are some common ones that that come up more frequently. So time off for medical appointments might be an adjustment. If someone's been absent for an extended period of time, let's say for treatment or recovery from or whatever it might have been, having a phased return to work. So rather than just going, on Monday you're in full week, you have, working 1 day a week or 2 days a week and kind of build it up. Adjusting your working hours would be a potential adjustment. Working from home might be an adjustment. Let's say your role normally requires you to be on your feet quite a lot, then having the provision of a chair or somewhere to rest would be an adjustment. Your equipment might be adjusted, so you might have special software on your laptop or whatever that allows you to continue working, avoiding your difficulties that you face as a result of your MS. It might be that your duties themselves are adjusted. So let's say there's a part of your role that you're now struggling to do that might be made not part of your role anymore, or you might have specific help with that. And it might even be that if your conditions kind of progress to an extent that you can't perform your role at all because of the nature of your role, it might be that an adjustment would actually be moving you to a different role entirely in the organization. If that's reasonable, and obviously that'll be fact dependent on whether that's reasonable or not, but that's a potential adjustment. So those are some common ones that come up, but essentially anything that might avoid disadvantage that you're put to as a result of your MS is potentially adjustment. Is potentially a reasonable adjustment. And the question is just, is it reasonable or not?
So it's best to sort of just have the chat with your employer about these things. Then.
Generally, it's the ideal situation, and obviously this isn't always the way it works, but the ideal situation is if you've got a kind of trusting relationship with an employer, or even if, let's say, you're in that position that we mentioned earlier, where it's not like all your colleagues know all the details of your MS, but you've had conversations with HR or occupational health that you discuss, that an employer then refers you to occupational health, and you have a conversation with an occupational health specialist about what might help me in this situation from a kind of medical perspective, and then you have a conversation with your employer, and really that your employer should realize that it's very much in their interests as well to be as kind of open and cooperative as possible, because otherwise they've got to, if they lose an employee because they can't continue carrying out their role without an adjustment, then they've got to go to all the work and costs of recruiting, hiring someone else, training them up, all those kind of things. So actually, in the round, it's often going to be by far the best solution for them to be to engage with and cooperate with a disabled employee to help them in the ways that they can to continue doing their role. it's useful to kind of keep a documentary record of the conversations you're having with your employer. So if, say, you want there's an adjustment to your role that you think you require, it's good to put that request in writing, potentially additionally to having an in-person conversation, but also make it clear that request is in writing, that you want a response in writing, that whatever is agreed is put in writing, that, after a conversation with your employer, you make a note of what was discussed, so that, you have that record, potentially for any internal conversations, if, like you say, it becomes a bit weird, or even, beyond that, if there is a kind of tribunal process or something, then that's all going to be really relevant. So keeping a good record of what's been discussed and what's been agreed is definitely a good idea. And one other organisation that can be really helpful source of support is dispute resolution assistance in the workplace, DRAW, which is a service offered by Yes Law, and they provide free mediation between an employer-employee. So if you are in a position where there is some kind of issue or dispute that needs resolving, then really there's no point at which it would be too early or too late to get DRAW involved, and that kind of mediation with an independent trained mediator can be really really helpful in bringing about a resolution to an issue. I mean, so again, the question of whether you should or not might depend on your individual circumstances. Generally, you certainly don't have to disclose it.
Yeah.
And in fact, an employer under Section 60 of the Equality Act, if anyone's particularly interested, is prevented from or prohibited from asking potential employees before offering them a job about their health. Other than for certain reasons. So, and if they do ask a question, if in the interview they say, ask a kind of question about how, about your health, then the disabled candidate subsequently doesn't get the job, they can claim direct discrimination, and the employer will have the task of proving that they didn't make that decision on the basis of what the questions and answers to those questions about someone's health. So the reasons when an employer can ask about someone's health prior to offering them the role are to see if someone can comply with the assessment process. So are there reasonable adjustments we can make to the recruitment process, breaks in the interview or whatever it might be, to see if you can carry out something absolutely essential to the role. So if you're being hired to be a scaffolder, then they can ask to make sure you can climb a ladder, for example. They can ask about your health for monitoring purposes, to see if a disabled person can benefit from some sort of positive action. So it might be that they have a guaranteed first round interview for disabled applicants, or there might be an occupational requirement. So the MS Trust might want to hire someone specifically with MS for a particular role, and that would be a genuine occupational requirement. So short answer is that generally an employer shouldn't ask about your health except for those reasons prior to making a job offer. So whether you do or not, it's kind of down to you. It might be that you have kind of sufficient trust in the employer that you're comfortable even at that very early stage being open about it, or you might very understandably prefer to go through the interview process, go through the whole assessment process, whatever it is, hopefully get the job and then think about disclosing it at a later point.